Good afternoon, everyone. This is Marc from AALU. Thanks for our second post-election webinar. I'm joined today by Chris Morton, who runs our Government Affairs Department, and Brad Campbell, the foremost expert on everything that is going to happen in the Department of Labor today, tomorrow, and forever. So,
wow, that is overbilling.
Yeah, well, we're fortunate to have Brad Campbell with us from Biddle. We're going to get into a number of things. It's been a eventful week, as you can imagine. You know, the transition team for President-elect Trump has been active in overdrive in terms of filling the 4,000 appointments. The President-elect himself gave an interview on Sunday night where he made some comments about health care that were had sent some ripples through Washington about covering pre-existing conditions and what that means to the broader healthcare overhaul. Mary Jo White, the SEC commissioner, announced she'd step down, and a whole host of other things that we'll talk about. But in the midst of all of this, what we recognize more than anything else is that, you know, this is among the most important time periods for your prospects and current clients to do their planning. We recognize that whether it's in an individual context or in a corporate context, you know, so many individuals, so many clients have to make decisions for what they're doing in 2017 and the fourth quarter of 2016. And so what we can promise you at AALU is that we want to continue to give you the tools that you need, not just to be informed, but to help inform the advisors, the referral sources, the clients who you know need to plan and who you know need the insurance that you're helping them acquire. But because of all the uncertainty in the marketplace, that they want to put it off. And we all know that uncertainty is the most harmful and makes the most harmful impact on planning. And this environment is among the most uncertain we've ever seen. And the only thing that will protect your clients is the planning and the services that you provide them. So with that, Chris, let's start with you, and then we'll get to Brad and the DOL. We'll work through it. We're also going to talk about some of the things we're hearing in transition. Again, I expect us to be on for about 30 minutes, and then we want to take your questions. So go ahead and click on the Q&A button and type in your questions. We'll get to as many as we can. Those we can't get to, we'll send out via podcast, we'll address, we'll follow up with an AALU member of the Government Affairs team. So with that, Chris, tax reform, state tax repeal, lots been talked about. Is this a foregone conclusion? Are we going to live in a world with 20% rates and state tax repeal? And is this a fait accompli? Fundamental tax reform is going to happen?
Well, Mark, here's the bottom line here in the near term is it's a clear area of focus for us here at AALU, and we have to be prepared and are preparing not only as an organization, but with our partners. But what's really important to know is that we should not, any of us, rush to judgments about what will happen and how it will happen in Congress over the next year. Again, preparation is key, scenario analysis, and we're doing that. But let me just speak to tax reform. I think reform in theory, as always, and as we've seen over the last few years, is widely supported. But when the details get revealed, particularly in legislative form, you know, dynamics and positions evolve or shift. And that's certainly the case in any legislative exercise. Over the next, you know, several weeks, the immediate and specific priorities of the new administration will continue to develop. We've obviously heard the Affordable Care Act is on the table for activity and review. Border security is a focus, and, you know, immigration more broadly. Infrastructure is at the top of the list, and, you know, potential jobs-related package. So all of those things have been clearly identified from the president-elect and the administration. We've had some statements about tax reform, but as it relates to tax reform, clearly the House majority has, their own timeline and plan, and they've been talking about it for quite some time. But how that's going to specifically map to the president-elect's timeline and plan does remain to be determined. Process-wise, when and if it gets done and how, it's open right now. Several other things I'll just say. Estate tax repeal has a cost. It's significant, over $200 billion over a 10-year window. Some on the Hill may feel that permanence has been achieved. The issue's been resolved with the fiscal cliff deal, for example. We've had an estate tax over the last 100 years for every year but one. And so we've seen up and down with the estate tax before. It's always come back with a new change in administration or congressional flip over. So, again, the question here of, what this looks like and how it gets done, I think we still need to see more details, hear more statements from, from congressional leaders as well as the administration, and ultimately see a package. And then, we're going to have more clarity. But preparation is key, and that's what we're doing.
Yeah, and thanks, Chris. And so much has been made about reconciliation, and I would expect we do have a reconciliation bill, but before they get that, they have to have, I think everything that I've read is that the mandate that comes out of this election connects more to repealing Obamacare probably than any other issue. And I think we can reasonably expect that will be a top priority. The president obviously talked about it. President-elect talked about it on the Sunday night 60 Minutes. But the whole reconciliation process, it starts with creating a budget, reconciling that budget, providing reconciliation instructions, and then if that all happens, which is not a certainty, although it's more likely than not, then the individual tax writing committees and the relative committees of jurisdiction have to pass bills that are reconciled, and if it's not offset with significant savings, like what happened in 2001, then it sunsets at some period depending on when the budget happens. So tax reconciliation bills have been used a number of times in the past, but again, there's got to be an equal share spending and more spending cuts than tax cuts if it's going to be permanent law. So Chris, before we get to Brad, maybe you could just summarize, what are the three things that we're doing in addition to preparing and talking to people to make sure that we're going to impact the debate on behalf of our members on the whole host of tax issues, whether it's inside buildup, whether it's on the corporate side, whether it's the estate tax. I mean, our industry is on the side of angels in terms of helping individuals and businesses plan, and we're going to certainly be active in any tax debate, regardless of what form it takes.
Yeah, no question, Mark. And I'll just start with, where our greatest strength lies, which is engaging our members. And through not only a call like this, but we're also and have established strategic working groups among the membership, on estate tax, on COLI deferred comp, on the broader tax treatment of the product, really to refine our message, focus our strategies, working with our issues committees, obviously our counsel, the board of directors. So the talent, the intellectual capital, the understanding of the marketplace of our members is so critical as we go through this exercise over the next several weeks and months. I think the other important thing to note is really important for the industry more broadly is alignment. So the close alignment and the communication with our distribution trade organization partners, our carrier partners, to ensure a very unified and consistent approach to this new environment. We've begun a number of those conversations, not just post-election, but going back through the last couple of years as we've refined our strategic direction. And that will continue on a regular daily basis to make sure we're marching together in the same direction in order to achieve the success that we all know we can. The final thing I'll say is knowledge is power, and we are working very, very assiduously to provide knowledge to the marketplace and to our membership to navigate today, not 6 months, 8 months, a year from now after things happen, but today on what can be done to educate clients, to talk to prospects, to understand the dynamics in the legislative process, what's going on, and how to make sure that folks are communicating effectively to folks across the table, in their business. And so that piece will be such an integral part of continued success for us and for our members.
So it's about engaging our members, working the Hill, being aligned with our industry partners, AALU, GAMA, NAPA, ACLI, NALBA, the whole group, and it's about helping our members. You'll get a Washington Report Marketplace tomorrow that you can forward on to referral sources, clients, prospects, that gives our objective third-party analysis based on everything we know and all of our experience. And you'll also look to get information on a regular schedule from AALU with FAQs, and here are some key data points that again speak to the need to plan in a world that is uncertain. I want to thank John Davis for your question on DOL and a couple other questions. Please keep those questions coming. Click on the Q&A button or on the chat screen. So Brad, you know everything about Trump, DOL, and everything to tell us. So in big picture, what does the president-elect, what's he going to do on some of the key regulatory issues, whether it's on DOL or 2704 or overtime rules? In your mind, what's going to happen on the regulatory front?
Well, I think there's no doubt that certainly on overtime in the DOL fiduciary rule, that we've had statements from the campaign that indicate that President-elect Trump is not a fan of those regulations, or at least the campaign says that it's not, and that they want to do something about them. Those affiliated with the Trump campaign have called for the repeal of the DOL fiduciary rule, for example. But in reality, what we have is now roughly 2 weeks, approximately, that's passed since the election, maybe a little less than that. And they're putting together their team. And until they have a team in place, we don't really have anywhere to go to ask some of these questions about, okay, well, what does that actually mean? What are we going to do? What are you going to do to actually pursue repealing the rule or amending the rule or delaying the rule? What is it that your plan is going to be to attack it? And I think it's important to understand at the outset that this DOL rule is different than some other regulations that the Trump administration has the ability to just kind of wipe out by executive order. On day one, I think everyone anticipates that then President Trump will come out with executive orders that sweep away Obama executive orders and stop regulations that aren't final, and tell the agencies to stop promulgating Obama administration policies where they can. This regulation, the fiduciary rule, isn't one that you can do that with. And that's because even though it hasn't gone into effect in the sense that we don't have to apply, it's what's called the applicability date. The applicability date is April 10th of 2017. But the effective date, when did the rule become good law? When was the rule on the books as something that you can only displace with another rule? That happened in the middle of summer, back in June. So in order to actually repeal this regulation, they're going to have to do a new notice and comment rulemaking to try and repeal it. And that, of course, takes time. And that's something they couldn't finish before April 10th. So I think a lot of people looking at that are saying, well, in order for this administration to be able to make considered decisions about how they want to proceed, whether it's repeal or amendment, whichever they choose, they probably need to try to delay the effective date as one of their first acts. And there are regulatory options for doing that don't require this full notice and comment rulemaking. So, for example, they could do a direct to final rule, or they could do what's called an interim final rule. These are both regulatory tactics where the administration could say, based on the findings, looking at the record and the good faith efforts to comply, yet how, big this hill to climb is and how many comments we've received that, the regulated community may not meet the deadlines and that this isn't going to be in the best interest of participants to rush to a rule when compliance isn't certain, and in fact, there may still be problems with the rule. We would say, of course, there are problems with the rule. For all those reasons, therefore, we, the Trump administration, could say the effective date is moved out 1 year, and we will now take comments on the action we just took to delay it. So an interim final rule, for example, they would actually change the effective date. They could delay it and then take comments on the action they already took. So there are ways for, under the regulatory tools at the Trump administration's disposal, to actually keep this rule from taking effect on April 10th. But they can't just sweep it away day one. And I think it's important everyone understand that. They're going to have to go through a process to change it, and that process is going to take some time. And that's why I think most of us expect that they'll try and delay it as kind of their early official acts on it. But again, they've only really had 2 weeks to put together the team and talk about what are we going to do and make plans. So, we're still trying to figure out what their approach is actually going to be. And I think the reality is it's just going to take a couple more weeks before they have the people in place to really send a signal about what their plan is going to be. But I think it's safe to say that they're definitely going to be looking at least fundamentally changing this rule and possibly repealing it. We just don't know yet what their people who are going to be taking over those jobs, what they're going to do and how they're going to do it. There's two other potential wildcards here for the fiduciary rule. One is we do still have the litigation going against this regulation that would seek to block it from being implemented. So there's a court in Kansas that hasn't yet ruled. There's a court in Texas that's just holding oral arguments, I think today, if not today, then tomorrow, to talk about whether this rule should be allowed to go forward. So there may still be a court ruling that strikes it down. And of course, Congress has been against the rule. They passed a resolution in the House and Senate this year disapproving the rule, but of course that was vetoed by President Obama. In a Trump administration, presumably there would be no veto, but for all the other things we just discussed, tax reform, immigration, Supreme Court justices, all those big picture issues that Congress and the president are going to have to work on here in the first several months, will they want to take the time to work on the fiduciary rule, which will no doubt be a fight in the Senate, where folks like Senator Warren and Senator Sanders will presumably push to keep the rule? Or will they say, let's properly something handled by regulation, why don't you guys sort it out? The last wild card, and I said there were two, but really there's three, and it's part of the litigation wild card, is if the litigation is continuing and we don't have rulings yet necessarily, will the Trump administration be able to take a different tack? The Obama administration has been defending the DOL, saying these rules are valid, and they've won one of the three cases, at least in the initial rulings. Will the Obama administration and its Department of Justice take a different tack and potentially agree to do something in court? And that'll raise some interesting questions. Can a court order do something that regulatory law normally wouldn't allow? So there's still some other decisions that need to be made outside of the Labor Department that could include the Department of Justice that could slow this down. So that was a long-winded way of saying this regulation, I think, and we all think, is going to be addressed. It's a little too early to know how, and there's a lot of different moving parts there. Last thing I'll say about the rule is, where does that leave us? I mean, can we stop working on compliance and wait for the word from the Trump administration about how they're going to address it? And I have to tell you, as an attorney who's talking to my clients who are, just doing a full court press to try to meet April 10th, and it's, some of them it's a question whether we'll be there, others will be there, but only with a ton of hard work between now and then. Are they going to be comfortable taking the risk that what if, and I just posed this, what if the Trump administration doesn't get organized quickly enough to stop this going into effect on April 10th? And if it does, will you be ready? And can you stop trying to get ready? What's your legal risk of getting sued on April 11th? These are factors that people have to consider. So what I'm seeing among our clients is people are still working towards compliance and hoping that in another several weeks, they'll get more clarity and can decide whether they continue to have to do that or not. But I think just you should all be aware, we are not seeing the financial services industry stop working on compliance simply because the president-elect is Trump, who presumably won't want this rule. They need a little more solid ground as to what's going to come next before they stop trying to comply with something that does have some big legal liability concerns about it. And that's probably the best summary I can give you as to what's going on there, Mark.
Well, that's great, Brad. And again, this is Marc Cadin and Chris Morton with AALU, and we're joined by Brad Campbell from Biddle, Counsel to a number of other companies, and again, one of the foremost experts on. Used to be in the Department of Labor under George W. Bush, so we've got the right person here. Let's go a couple of grains of sand deeper, Brad, in terms of the why we can't just sweep it away. The why can't we just get a White House executive order? Does this have to come from the White House? Does it come from DOL? How relevant is the Department of Labor secretary, who we currently don't know, in that decision-making process? And then, sort of what's that process look like, and why, or do we have to wait a few more weeks / potentially several weeks before we know exactly whether it's going to get repealed, delayed, or what have you?
Yeah, so think of it this way. If Congress passed a law that didn't take effect for 2 years, but it was a law that was written down valid on the books, you wouldn't be able to, you'd have to have Congress pass a law repealing the law that they already passed, even though it hadn't taken effect yet. And regulations have kind of a similar situation. Just the easiest way to think of it, there's a law called the Administrative Procedure Act, which governs how regulations are made. And there's amendments to that. Another one is the Congressional Review Act. And when you put all those different administrative laws together, what they basically say is once an agency has issued a final rule, if it's a big significant rule like this one, it cannot go into effect, meaning become good law that you'd have to do a new regulation to displace or change until 60 days has passed, giving Congress time to do something about it if they don't like it. Well, in our case, DOL put out the final rule in April of 16, which means by the end of June in 16, it became a regulation that's fixed in the books. And under the Administrative Procedure Act, to change existing codified regulation, even though it hasn't actually been something people have had to comply with yet, you have to follow the same rules as if you were making a rule. So that's the reason that they can't just by executive order squash this. Now, some of you might say, but wait a minute, I remember at the end of the Bush administration that the Obama folks came in and squashed some rules. And I have to say that actually happened to a regulation that I had put out as the Assistant Secretary of Labor for EBSA that was trying to make investment advice more available to people. But what had happened there is that rule had only been published in the Federal Register for a few days. And so they were able by executive order to squash it and not let it go forward because it hadn't yet become, so to speak, good law. That's the problem here, is it has become good regulation that's on the books. So that's why they have to look at probably a delay approach to avoid people having to be in compliance by April 10th. Again, though, they have all the regulatory tools at their disposal to make all the changes that we could come up with. I mean, whether it's repeal, whether it's significant amendment, they have the authority to do all those things, but they have to follow the right process. And that process takes time. You have to have, propose the regulation with the economic analysis. And then we all have to have, generally speaking, about 60 days to comment on it, submit those comments to the Labor Department. They have to review them, et cetera. And that just takes time. So that is
Brad,
an unfortunate situation.
And all that process has to happen after the Department of Labor Secretary is confirmed. Is that correct?
Yes and no. And what I mean by that is the White House could direct whoever the acting Secretary of Labor is before there's a new secretary in place and say, we want you to issue this regulation. And generally speaking, that would then happen. So if, for example, we're talking about delaying the effective date with an interim final rule, as long as the instructions include, the actual rule that's been written properly, that checks all the boxes it needs to check about why this interim final action is appropriate under the Administrative Procedure Act, again, the rules for making a rule, as long as they put together a good regulatory package and it checks all the boxes, that doesn't have to be held until there's a new labor secretary. That could go out under the existing authority of the acting Secretary of Labor. And presumably that's what the White House would be looking at doing. But we don't know that for sure yet. And we also don't know how controversial whoever is going to be nominated for Labor Secretary will be. So we don't know if that'll be a long confirmation or a short confirmation. And that might influence how they choose to do it. For example, they might want to put that delay regulation through before the nominee is taking office, because then it potentially takes it off the table for the nominee to deal with and might make the confirmation easier. Alternatively, it might make it harder. I mean, there's some political calculations there as well. But so legally, yes, we could do it before the new secretary is appointed. And it may well need to happen that way, just given the amount of time it might take to go through the confirmation process.
And last question for you, Brad. I want to get Chris in here. Based on everything you're hearing, we get a number of questions on our Q&A box, so thank you for submitting those. Number of questions relating to, there have been companies that have made choices about commissions, about business models, about what products are available to be sold, etc., based on complying with this rule. In your minds, give you kind of two parts to it. One, based on everything you know, are companies going to peel all that back? Are they going to go back? And then two, do you think most companies are going to be satisfied with kind of a repeal, just get rid of the rule and let's see what comes next?
Those are great questions. Yeah, the industry as a whole has already spent literally hundreds of millions on compliance. And they've made business decisions and started to implement business decisions, some of which are not easily changed at the last minute. So I do think even if this rule is repealed, even if it is substantively modified, some service providers, some carriers, some various intermediaries are probably going to retain some of the changes they've made. But I think that's going to be a very highly individualized decision. And so, will we see things return to exactly the status quo they were before? I think that's probably not going to be the case. Will we see anything approaching what the Department of Labor envisioned? I don't think that's the case either. But I do think there are some things that probably will prove to be changes the industry retains, sort of regardless of how the rule goes. But again, we don't know what the Trump administration plans. If the Trump administration says very clearly, we are going to repeal this thing, we are not going to modify it, that's a different situation than if the Trump administration says, well, we like the notion of the concept of acting in the best interest. That's a good concept, but let's fix the problems with executing that concept that the Obama administration put in the rule. That's a very different place. And I think you're going to see a different set of response from the regulated folks. So again, as unfortunately with the situation we're in, that was a long-winded way of saying maybe, but we're still speculating a little bit. I do think we're probably going to see at least some industry players keep some of the changes they've made. There's others, though, they're going to be very happy to not go near. So, it's up in the air, but I think I don't think we're going to return 100% to the status quo.
Yeah, well, and from January 20th inauguration day to April 10th, a short period of time, seems like all roads lead through, at a minimum, delaying the applicability date, and then sorting out what happens after that. And again, 1 year seems like even a short amount of time relative to some of these judgments that need to be. But that we'll leave that to another story. Chris, give us the position AALU has on DOL and what's our action plan?
So clearly, Mark, we're working in concert with our industry partners, as I said at the outset, to make sure that we're making the right judgments that are going to be effective and work in terms of sticking. Delaying this certainly is part of making judgments around what the best approach is. So as we look through this, all of the problematic provisions, whether it's the private right of action or some of those other, initiatives that are part of the rule, those are all things that are going to be part of that conversation as we move ahead and make sure that we have an outcome here that we all can be satisfied with. The other thing I would just say is, to Brad's point, I think it's really important for the membership that they continue to understand that we're going to produce analyses of the rules provisions. Brad just completed some work for and with us on 8424, and proceed appropriately about what they need to do to be prepared. Again, there's uncertainty here. There will be change. What the form of that change is, we don't know, but we do know that we don't want to get caught. So we're going to make sure that we provide tools and resources to make our members fully aware of what the rules provisions mean today.
Thanks, Chris.
Just as another example of that, we're waiting for DOL to issue some additional guidance. We don't know whether they will or not in this administration, but if they do, we will, I think, want to analyze that for you and explain what it means on the off chance that it does become applicable. So I think, Chris, what you're describing is exactly the right and most prudent steps to take.
Well, before we wrap up in the last couple of minutes we have together, Brad, Chris, anything else that we should be covering that we need to make sure our members are aware about as it relates to DOL and the regulatory process?
The only other thing, Mark, I would add is, we're here as a resource. So continue to bring your questions, your thoughts, concerns. David Hollingsworth here on the team, myself, certainly reach out, and to whatever extent you need assistance with Brad's expertise and our approach, I think we'll be able to provide that continuing on an ongoing basis.
Yeah, right on. And I would just, as we close out, maybe we'll spend 2 minutes on the Trump transition and kind of what we're hearing. We believe that AALU members serve the best interest of their clients every single day. And we're going to continue to promote that. We also believe not in conforming to the rules that have been adopted in the UK and Australia and elsewhere where commissions were banned and consumer choice was reduced. We believe that you can operate in a commission-based model in many instances that is much better for clients than the alternative. And so we've been aggressively advocating that throughout this debate, working with industry partners. We believe that we have to do more as it relates to promoting the benefits of a commission-based models, where there are so many detractors out there that would say fees are good, commissions are bad. The members in the AALU and throughout the industry know that's simply not the case in all circumstances. And what consumers really need is choice. And that's what we're going to continue to advocate for. So we will stay connected and engaged on that. Chris, maybe I'll just flip it to you in the last minute we have to talk about kind of the transition team. What are you hearing? Key appointments, other industry lobbyists, fellow partners at ACLI, NAPA, et cetera. Maybe you can just provide a little bit of transition gossip as we close out the webinar.
Yeah, thanks, Mark. Well, clearly moving through the process in terms of the transition is for many in the campaign of President-elect Trump a very new process. I think what's clear is there will be bumps in the road and just kind of navigating from their end and kind of understanding what that process entails. We'll continue in concert with our partners, as you described, investigating opportunities for dialogue. I think that's really important as we get to know folks who are joining the Trump administration and the team there. In terms of key appointments, clearly everybody had seen Reince Priebus coming over from the Republican National Committee to now be Chief of Staff for the White House and for President Trump, or President-elect Trump. Clearly, he's close to Speaker Ryan, both from the state of Wisconsin, and that will be a dynamic to watch as the legislative process unfolds. We've heard, at Treasury, and I think others have seen this, but Steve Munchin at Goldman Sachs, or a former Goldman Sachs executive, is someone under consideration there. At the Labor Department, there's folks from the EEOC and former administration officials that are being looked at. The SEC, I would say, is most interesting. Obviously, we have Mike Pivovar, who's there now and came from the Banking Committee previously, someone we've worked with closely. Dan Gallagher, a former Republican commissioner, is being looked at and discussed or floated. Paul Atkins, also a former Republican commissioner. So there's a number of names, people who we know or are familiar with their work. As we talk to our colleagues, at the various government affairs operations with the companies and with the other trades, the key to remember here, and I think we're all really trying to level set here, we've been through challenges before. We all know how to do the work of advocacy. And from an AALU perspective, we have the strength of tremendous advocates and relationship builders amongst our membership. So as long as we're putting together, and we are, the strategic plan and approach to deal with the challenges that lie ahead, that is something that we can accomplish in tandem. And communication is going to be critical. We know that, and we're committed to it. And we want to make sure that our members are understanding of that and working together with us to raise questions so that we can respond, but also give us insight from the marketplace so we can appropriately shape solutions. So there will be more to come. Alignment is going to be critical, a unified approach and collaboration. All of that are going to be hallmarks of ultimately the success we're going to achieve. So with that, Marc, I'll turn it back to you.
Thanks. On a little bit of a lighter note, Brad, are you going to be the next Labor Secretary?
If so, nobody has asked me, which I certainly am not surprised to find no one's asked.
Fair enough. Well, we run a little bit over, but Brad, thank you for your insights. Chris, thank you for your leadership and what you do every day. And most importantly, thanks to all the AALU members, the Issues Alliance partners, the key stakeholders that have called in, participated, sent questions in. Keep them coming. communications@aalu.org. Email me, Chris, pretty much everybody on this call but Brad, and we really appreciate the partnership, and we will stay in touch. Thanks, everybody.
Thanks.